Good afternoon, everyone. Thank you for joining us today. Welcome to your mid-year labor law update sponsored by the Workforce Development Board of Alameda County. My name is Stephanie. I'm the marketing director here at California Employers Association. During today's training, we're going to have a lot of polls for you. So I'm going to launch a quick poll about your HR hotline just to get you ready, have a little practice for some of the polls coming up. You can just select your answer. You'll be able to see what your peers are saying by a percentage, so that is always very fun. And as you can see, your audio will be muted throughout the presentation today, but there are going to be lots of opportunities to engage either through these polls or through the chat box. So don't be shy about talking in the chat box. At the bottom of your screen, there's a speech bubble. That is your chat box. I'm going to be dropping our handouts in there shortly. You'll be able to click the icon of the handouts to download them to your desktop. If you have any questions about the content of the presentation, put that in the chat box. If you have any technical issues or troubleshooting, also put that in the chat box. That is where we will interact with you the most today. This webinar will be recorded, and the team at Alameda County will reach out when it's available for playback. We will also be inviting you to share your feedback at the end of today's training by participating in a brief survey. It's only a couple questions. It'll take you less than 2 minutes. I promise it's very short. We love getting your feedback to make sure we are meeting your expectations and see what we can do to improve these presentations. It's also a great place to put any future topics that you would like to hear about. Again, your training today is brought to you by the Workforce Development Board of Alameda County. And I would like to introduce our trainer today. We have Astrid Servin, one of our human resource directors, leading today's session. So with that, I'm going to pass it over to you, Astrid.
Great. Thank you so much, Stephanie, and good afternoon. I hope you grabbed your lunch and are ready to spend your lunch hour with me. I'm happy to be here. And thank you for answering the poll. Sounds like some of you have not called in. Some of you have not, and this is the first time you're hearing about it, so welcome. A little bit more about your hotline here. We like to partner with Alameda County's Workforce Development Board to offer this complimentary hotline that we partner with your county with. Darlene, I noticed you just stepped in. Did you want to speak to the hotline? I'll give you a little time here.
Yeah. Hi. Yeah, if you take the opportunity to call the hotline, and it's really a good resource. We are actually even looking at using this as a resource internally to answer any questions that you may have related to your business. This is a really good resource if you're starting a business, if you already are in the startup process, or if you're an existing business, maybe you don't have that HR team that you can turn to. You can utilize this as a resource, and we've so far received really good feedback from it. So thank you for allowing this opportunity for the Alameda County Workforce Development Board and the California Employers Association to be able to share this information with you. Feel free to reach out to our team with any questions, and thank you.
Great, thank you so much, Darlene. And yeah, we love partnering with Alameda County. We've heard from your county employers out there, so tell a friend if you were just hearing from us now for the first time. But when you call in, just to kind of get an idea, you're calling in and you're talking to an HR advisor such as myself. We all take turns here at our company, the HR directors, in fielding these calls, and we generally say to keep the calls about 15 minutes or so, and we'll answer any kind of onboarding question, everything in the employee life cycle, from onboarding all the way to termination, and actually even pre-employment, because there's a lot of things that go into pre-employment as well. So, and everything that goes in between. So give us a call. Sometimes you know the answer, you just kind of want to talk it through with someone, and that's what that hotline is there for. So happy to be there helping you all through navigating some HR issues. So California Employers Association, we are an HR company, consulting company. We have also membership. If it's something you need that's beyond the hotline and you need additional guidance and additional support, you may want to consider membership. We'll talk about membership towards the end of the presentation as well, if it's something you'd like to consider. You already have the hotline, which is a free resource, but if you need additional support and you're looking to have your HR department or a non-existent HR department, maybe you're an office manager, a general manager, and you're looking for things such as forms, templates, policies, guidelines, fact sheets on a variety of topics. If you need training for your management team, specified training, individualized training, consultation if you need help with workplace investigations or negotiations if you're in a labor union environment, things like that. We offer quite a bit of support in the HR field. So you could visit us at employers.org. We also offer free resources for employers throughout the state. Our members come from even out of the state. Sometimes we have out of state employers who need help in California because we are a unique state, as you all know. And as you'll know from this mid-year labor law update, there's quite a bit of changes too. So what we are not is a law firm. We don't offer any kind of legal advice, either on the phone or through these trainings. This presentation should be relied upon just as educational in nature. We are going to talk a lot about laws. It's called the Mid-Year Labor Law Update. However, should not be relied upon as legal advice. Consult with your own attorney to speak to them, and your information that you talk to your attorney will be confidential and privileged. We want you to have a great partner with us and with your attorney's office. A lot of times we get you to the place you need to be to then speak to an attorney, saves you some money. You'll know exactly what questions to ask because, as we all know, they can be costly. We also offer partnerships with employment law attorneys that we can assist you with as well. So let's get started with this training. We've titled it Navigating a New Administration. And there's a reason for that, right? We're living in unique times right now with the new administration. And there's been quite a bit of federal developments that have been all over the news that have increased starting in January, of course, and then kind of taking turbo speed in the last month or so, increasing awareness in especially California. So we're going to talk a lot about that and what that means to you as an employer. So we'll discuss some of those executive orders and the employer impacts. We'll talk about some wage and hour updates, mostly in the state of California, where those will impact your California employers the most. And then we will then look at new case law and regulations. It's not always that we get a new case mid-year, but we have a few that we will discuss and how they impact you and how, or maybe even affirm what you've already maybe been doing. So that's good. And then we'll talk about we'll close out with some summer reminders for California employers, mostly having to do with safety. Cal OSHA has a lot of things that they want us doing, and they were pretty silent for a long time. And suddenly it seems like last year they've had some new updates and new requirements that are ongoing. So we'll remind you about those as well. So let's start off with those federal developments that have topped the news relating to mostly immigration enforcement. We're going to start with the I-9 form and talk about those audits and what the form means, what employers should be looking out for. And we want you to have a I-9 compliance process or a procedure that you're handling, that you're doing, that you're aware of in your company. We've heard that there is a stated goal of about 12,000 to 15,000 I-9 audits that will happen by ICE this year, which is a huge number. It's a huge increase that we've ever seen before. So we're, hearing about certain industries that are being targeted, some that are more vulnerable to others, such as agriculture, hospitality, healthcare, places of employment that are more public in setting, and also cities that are considered what they call sanctuary cities, such as LA. So it's important to know that what is a compliant I-9 process? Are we following it? Are we following best practices and best procedures to put us in a good position to be ready? Should we have a notice of inspection from ICE, or should we call what they call an ICE raid happen? And we'll talk about those differences. So we'll also talk about unique California requirements, because if that should happen in your location, California has some unique requirements so that you need to be aware of. So we'll need to discuss those as well. And then the executive orders, there's quite a few of them. We're not going to discuss them all, or we'd be here for quite some time. We're only going to discuss those that impact employers in the diversity, equity, inclusion space, and those implications to possibly your DEI programs. We'll try to shed some light. There's been some confusion on that, so we'll discuss those as well. So let's refresh everyone about what is the point of an I-9 form anyway. Why do we have it? Well, it's a federal law that requires employers to verify the identity and the employment authorization or eligibility to work in the United States for all newly hired employees. And this is not a new rule, obviously. It's been around for quite some time, since 1986, in fact. So unless you have employees that were hired before then, you have to complete an I-9 form for all your employees. And those are employees. We're not counting independent contractors because they are not considered employees. So if it's an independent contractor situation, That's a different story. We don't store an I-9 for them. But generally, the process is that the individual gets to pick, again, how they identify themselves and how they're eligible for employment. What the employer is responsible for is ensuring that we're telling them they will be verified, their employment status will be verified upon onboarding when they start with us. And then the responsibility of the employer is to make a reasonable effort to make sure that those documents appear genuine and that they're reasonably related to that employee. So it's not filed with the government agency. We don't put this anywhere with the federal agency. Our duty is just to maintain these records in a compliant way and make them available at any time for inspection. So there are the reason why this is important is that there are very high costs associated with penalties if we get it wrong. And I-9 forms have to be completed and filled out and corrected if we do make a mistake in a certain way. They're very particular about how we correct these. So the penalties can range from $300 for something very minimal to egregious or willful violations could be as high as $28,000 per violation. So we want to make sure that you're doing this right, that you have an I-9 for all your current employees and any terminated employees that fall within the time frame of when you're supposed to keep an I-9, which we'll discuss too. So we're going to talk about those. So I-9 forms are required again for all employees. They need to be done within a certain time frame. So we're going to talk about that. And sometimes these issues get tricky. We have unique situations, and utilize your hotline for those unique situations. We get those tricky situations sometimes where we need to look up certain things with you as well. But there is a wonderful resource that's available to answer most of your questions called the Handbook for Employers. And it's called the M247 Employer Handbook. It's published by the USCIS. And it's a great actual resource. That's where we go to. If you were to call us, we would probably look in there if we can find it quickly for an answer. So just know that that's a great resource. Should you get something, maybe a form that you're not sure if that's an acceptable document or if it's an expired document, but it could still be valid, possibly, depending on the type of documentation you have. So let's take a quick poll. Stephanie's going to launch this one for me here. And the poll is, have you audited your I-9 forms within the past year? We just want to know, we're curious if you've done an audit, if you have a procedure for conducting these I-9 audits. And we'll take some time a little bit to see if you've done, maybe you're not responsible for doing one, maybe you're not sure if you even have to do one. So typically it ends up being the responsibility of the HR department, but if you are a very small employer, then that responsibility will lie on the general manager, the owner of that location, of ensuring we have one. And recently I did an I-9 audit for a company, and it was the owner who asked me to do the I-9 audit, and it was the owner who did not have an I-9 audit. There was an I-9 for everyone except the owner. So sometimes those things happen. You know, we get caught up in what our responsibility is and neglect to even do our own. And that's true of HR people as well. So thank you for sharing that for me. So it sounds like, yes, a lot of you all have. Some of you have not started that yet. So I appreciate your participation in that poll. We're going to talk about that because even if you have done that, we want to make sure that you've done it correctly and all that. And then just in your chat box, just to keep this interactive and keep you awake here through this, let's do a little pop quiz. Locate your chat box if you'd like to participate. And let's say your new employee started work on Monday. When would be the deadline to complete their I-9 form? Would it be A, Monday, on or before their first day of hire? B, Thursday, within 3 business days of date of hire? Or C, within 7 calendar days of hire? So let me know if you'd like to participate here, which is the correct one. If there's a deadline for completing an I-9 for your employee who just started, would it be on or before the date of hire? Would it be within 3 business days or within 7 calendar days of hire? So if you'd like to participate, and you can if you don't want to do it publicly, you can do it right just to the host and panelist if you'd like as well. Good. Good. Okay, so you guys are pros. The correct answer is B. Under most circumstances, of course, you will have until Thursday to have completed your section of the employer section within 3 business days. But remember, there's 2 parts to an I-9. We have Section 1 and we have Section 2. Section 1 has to be completed by the employee on their first day of work. So that is where they're affirming and they're stating their attesting to their identity and authorization to work. And then in Section 2, we're reviewing that employee's documentation that they brought in. And they do have 3 business days to do that. And so we need to complete that correctly on Section 2. And the exception would be if there is an employee who works less than 3 days for you. We're just hiring them for an assignment. Or it's a tricky situation where we don't hear from them again, and we've only hired them for a short time period. We really should have completed all Section 1 and Section 2, especially if we know that this employee is only working for us for 3 days or less, then we need to complete that on day 1. So due to California wage and hour laws too, if you're asking an employee, I know this is sometimes, it used to be more common practice with employers where we would, at the time of job offer, give them the I-9. You can still do that. You can give them the I-9. But then we'd ask them to complete that before they came into work, before their first day of work. And we recommend against that because wage and hour laws in California are so strict that they say simply completing a form, which is an onboarding form that only new hires fill out, is something we should be paying them for. So if you are doing that, just know that you should pay them. If you're like even sending them home with a new hire packet and having them fill that out, that we're paying them for the time it takes for them to do that. And of course, C would be incorrect. We don't ever want to do within 7 calendar days. There's not a rule that says we could ever do that. So if your employee is failing to provide all that, typically we need to terminate that employee until they're able to provide that documentation because they're not legally allowed to work for you without this authorization. In the event of an error, so you like, oops, we didn't know that was the process, or somebody had this department before I did and they weren't doing it right, then there is a process to follow when that's part of your I-9 audit, and there's guidelines to correct that error as soon as possible. It would require a written explanation that talks about what happened, what is it, and we'll talk about that a little bit more. So you must be aware there is a new I-9 form out there. There's kind of 2 out there. In August 2023, we had some major changes that that really drastically changed that. It reduced Section 1 and 2 to a single-sided sheet. It's designed to be a fillable form on tablets and mobile devices, which is really neat. So you can do some online, you can send these paperwork, and we're more modern now so that we can fill those out online. And then it moved the Section 1 Preparer Translator Certification to a standalone Supplement A. So if you were helping someone complete the I-9 or translating it for them or preparing it for them, then that used to be on that same form and we had to attach it. Now they just moved it. It's not something that you need to keep unless you use that Supplement A. And very similarly, it moved Section 3, that re-verification and rehire section. That's also now a standalone Supplement B. When there is a re-verification, you need to sometimes re-verify a work permit, for example, or work authorization, excuse me, that maybe has expired during their employment, and you need to re-verify that work authorization because it's a temporary work authorization. At that point, you would redo the re-verification. Again, you need to include that in the I-9 if it's applicable to that employee. Or if you're rehiring them within 3 years, you could use that same I-9 and just do Supplement B to attach to that original I-9. You could also just do a whole new I-9 as well. If you're doing a rehire, whatever your process is okay, either one. But there is a new January 2025 version that has an edition date of January 20th and an expiration of May 31st, 2027. And that was to align with the ideology and policies of the current administration. So very minimal rules and very minimal changes to that. But just know that that was the reason why there was a change to the I-9 beginning of this year. It was due to that administration change. So this is kind of a big question here, when should I start using the updated I-9 forms for new hires? And we recommend right away. You are actually allowed to use the I-9 from August 1st, 2023, the one that you probably were using, last year. And you can still use it because it has an expiration date of July 31st, 2026. So you can, I-9 forms can be used until they're expired. So technically you can continue to use that one, but there's a greater chance you might forget to switch to the new form when required. So CEA recommends, there's a new one. Is if you're not going to remember to update it come July 31st, 2026, then maybe just start using that new one now. But just know that both are acceptable legally. And again, sometimes with rules and laws that change or executive orders that are passed, you would never know. It might have been where we should have just been using this one and they go back. So our recommendation is just start using this new form now. So should I correct or replace I-9s of current employees because there is a new form? This is actually a question we get a lot into the hotline is, should I just change them for everybody that we have? And the answer is no. As long as the version you use was not expired when the I-9 was completed, then you should not update your I-9 forms or re-verify based on a new form version. So don't need to go through that whole I-9 process because of this change. So long as you were using the current form. Now it could be that we weren't. We didn't even realize the I-9 changed in 2023, or we have someone authorized to verify I-9s, which is typically what happens, and they forgot to update their I-9 form on their onboarding packet, and they're still using an old I-9. So if that was the case, then you do need to update that with the new form. However, what we recommend is it will require an attachment of a memo, a written explanation explaining that. Okay, so let's talk about remote verifications because we do have work environments out there that are hybrid or that are work from home. So this is a new development related to I-9, which is E-Verify mostly. So as a refresher, for an I-9, an employer or authorized representative must review the documentation and employee's physical presence. So we typically have to have that face-to-face meeting. Now that was relaxed during COVID. And so we were able to hop on a Zoom or do a FaceTime with an employee and review documentation that way. And we didn't have to necessarily be present. Well, for 2025, that flexibility has ended. So as a general rule, you or your authorized representative that you designate have to have that face-to-face meeting to verify the documentation. In California, it does prohibit the use of notary public. Sometimes your I-9 says that, but in California, we cannot do that unless they're a registered or bonded immigration consultant or licensed attorney. Excuse me. So the remote verifications, very limited, can be done, very limited basis, only for employers who participate in E-Verify and that are in good standing, meaning they're following all the procedures to be in good standing. You have to be told you're in good standing in order to do that remote verification, only if you're doing E-Verify. But even then, you're subject to quite a bit of requirements, even if you are one of those employers that meet the exception to be able to do remote verification. Things like the employee needs to send you copies of the document prior, the front and the back, prior to your meeting. And then there has to be a live video that takes place to review those documents that they showed you in that copy that they sent you ahead of time. And then that person needs to verify that they are actually the same one. So a little bit more scrutiny on the employer part to verify that what was sent to you prior to your meeting is the same as the one you're now reviewing in this live video that you're having with them. And then you have to check that the box on the I-9 that says that you use an alternative procedure. So just know that that is something, if you want to start the E-Verify process and do something like that, if you are maybe 100% remote or very hybrid, or you have employees all over California, this might be an option, but just know that there's requirements you have to meet in order to be able to do that. Okay, so there is an increased inspection of I-9 audits right now. I'm sure you know about that. Light of immigration enforcement is high right now, and it's a priority of this administration to manage I-9 audits. So that's why there's an increase in that. So we do recommend you audit that. Some of you have already done that. Some of you have not. And, maybe you're in a workforce where you feel like there's less scrutiny on you in an industry that maybe doesn't shed as much of a bright light as others. However, Regardless, you should still have an audit done to ensure that you've done things correctly or that the previous manager who was in charge of this did it correctly. Because you do have an opportunity to correct errors before you have a visit by ICE. It shows good faith on the employer's part, and again, just puts you in a better position because penalties can range so much. So that good faith goes a long way to maybe having some sympathy with ICE and correcting these errors ahead of time. And that good faith clause really does count for something. So the USCIS does recommend these audits be done and that we do these in good faith and that we follow their procedures that they've given us to ensure we're in compliance. First of all, you want to discard any I-9s you're no longer required to retain. Remember, you have to retain those I-9s for any current employee that you have, and then any former employee, you could get rid of them unless they it's been 3 years. You have to retain it for 3 years from date of hire or 1 year from the end of their employment, whichever comes later. So there's like a formula you have to follow. If you're a CA member, we have that toolkit you can use for an I-9 audit, which is great. And it has that formula for the 3 years from date of hire or 1 year from the end of their employment, whichever comes later. So it'll always be a minimum of at least 3 years, but you may have some. I know when I used to work in the office in the field, we had some I inherited for like 10 years and they were just there for too long. So we recommend discarding those you don't need to have because there could be some errors on those I-9 forms that they can penalize you for. And you don't want all that documentation out there or exposure to I-9s that weren't done correctly. If you correct an error on the I-9 and it's something you can easily do, generally you would just draw a line through that incorrect information, enter the correct information, for example, above it. You would initial and date the correction, and the date needs to be in that format that they like to use, the 2 month, 2 day, and 4 year. Never backdate anything and never use whiteout. Whiteout is a no-no. So if you discover I-9s, I know I do when I do audits with whiteout, the USCIS sees that as you're trying to conceal something or you're trying to do something erroneously, and so they don't want to see whiteout. And so you'll have to correct that with a memo stating that you understand you weren't supposed to use that whiteout, but it was used, and so you're again in good faith auditing that. So prepare that written explanation whenever it's needed, whenever it's something that you need to explain what happened. Whiteout will be one of those examples. Also, terminated employees that you can't correct because the employee is no longer here. So maybe we forgot to check those I-9s. We didn't really verify Section 2 and we didn't do it correctly, or the employee missed a signature on Section 1 and they're no longer here, but we still have to retain that I-9. You would prepare a written explanation making that statement and saying why you're unable to correct that, but you're doing that in good faith, and that serves as being in compliance with I-9. The other thing I was going to do is never discard an I-9. We're always going to keep it. So even if it's incorrect, it has a lot of errors, we're going to attach that I-9 to the new I-9 if we need to do a new one, but never discard or try to cover up those errors. We want to just, again, in good faith, correct them. Section 1 has to be corrected by the employee only, and Section 2 has to be corrected by the employer only. So, and again, attach that memo explaining what happened. So if ICE or another enforcement agency comes knocking on your door, remember California's unique requirements. Prepare to provide I-9 forms and requested records within 72 hours. It's recommended you keep these I-9 forms in a binder. If you've done any kind of labor law update with attorneys, they always say, please just take them out of the personnel file, put them it's recommended in their own personal little binder, and then keep them maybe one for active employees, one for terminated employees in alphabetical order. They're ready to go should you get an inspection. You have to post a notice of inspection for employees within 72 hours. So if you are told that you're going to have an I-9 audit, it is a requirement for you to post this and give employees a heads up that you've received a notice that ICE will be inspecting. We need to post that in the language that we normally use to communicate with employees. So if we normally translate policies into another language, you should be doing the same for this notice. And the Labor Commissioner does have a sample notice that you can use for this purpose as well. And then we need to physically provide government findings to identified employees within 72 hours. So if ICE does identify a deficiency on an I-9 record or an individual possibly not being authorized to work for you, you need to physically provide those government findings to that identified employee within 72 hours. Now you're going to run into a situation possibly where you can't locate your employee. Maybe they fail to show up, they stop reporting to work. Your obligation is to communicate that via email or mail. Try to let them know and keep record that you've done that. Now, a notice of inspection, it is very different than what they call an ICE raid. An ICE raid is typically referring to ICE not sending a nice notice in the mail, but rather showing up at your business uninvited to speak to your employees or even to possibly arrest someone. So here's some tips around that. Note that you may refuse to allow ICE to enter any non-public areas of your workplace unless they have a valid judicial warrant. And what you can do in your company is if you have maybe where customers or your patrons kind of congregate, you have an area that's considered public. Also, your parking lots are considered public. If you are in hospitality or if you're in housekeeping, that kind of stuff where there's hotels, restaurants, that's all public. So ICE can access those areas. If you have concerns regarding this, you can make areas that are private or employee only very clear. Make those markings about privacy of employees only to identify that it is not a public space. You may also consider working with your council on what they call ICE drills with preparing employees so that they're not panicked. Should that happen, what do you do? Who are they authorized to talk to? What their rights are as employees to remain silent, because workers have a right to remain silent. And then another training you can do is to let them know that they shouldn't run if an ICE agent approaches them, because that could give them a basis to arrest them. So some good resources there for you to have. There's also some articles that we have written here at CEA that can help you. I'm going to put one of those in the chat right now that we've done, some blog articles that we've written regarding this. So that is your responsibility here in California. So to kind of end this section here, we want some bullet points here. Ensure a compliant process for completing Form I-9s at the time of hire. Audit those I-9 forms and record and records annually. We want to make sure that we're up to date, again, especially if you've inherited these I-9 forms. And then be prepared to follow California's unique requirements for notice of inspections. Talk to your management team, your leadership about those unique responsibilities here in California. I did an I-9 audit recently for a company with about 20 employees. It took me a couple hours to do that audit, so it wasn't a whole lot of time, but it was definitely worthwhile. We found quite a bit of discrepancies that we were able to accommodate and clean up through memos. So highly recommend that. If you're a member, you have access to our I-9 self-audit toolkit, and you could always schedule CEA to conduct your I-9 audit for your business as well. Again, a couple hours for some employees would save you time too if you don't feel like doing it. Okay.
I'm going to jump in real quick here, Astrid. We had somebody chime in the chat box with a few questions for clarification about the Form I-9s. So someone was asking, does there need to be an I-9 for every active employee, including the owner?
Correct. If the owner, thank you, Stephanie. If the owner is an employee, is on your payroll, then they need to have an I-9. And yes, any active employee, not independent contractor, not volunteer, but any active employee that's on your payroll has to have a current I-9. Yes, thank you. Good question. And yeah, keep them coming. And if Stephanie, go ahead and feel free, because I think my chat's not lighting up, so I'm not able to see when it lights up there. So yeah, chime in when you can.
I'll be happy to jump in. Make sure you guys are putting all your questions in the chat box, and we will keep answering them as we go.
Thank you so much. So another issue getting a lot of attention this year is diversity, equity, and inclusion. So a little bit of background, a little bit of a history lesson here. Diversity programs first appeared in corporate America in the 80s and 90s. And that really was an increase to kind of just get some global competition so that we could remain current. And it's gone through some ups and downs, and the focus was increasing our workforce and diversity. And I think we made great strides in the 80s and 90s. Things kind of ebbed and flowed in companies. And then the focus became these DEI plans and programs, and they were really getting up to speed on those things. And then there was a spike in attention, if you can recall, in 2020. Reports indicate that there was an 123% increase after what they call the George Floyd incident in 2020, which caused kind of a shift and a big awareness, a cultural shift. But then more recently, so 5 years later, in 2025, there's been another cultural shift with large companies pulling back from DEI programs and initiatives. And arguably, these executive orders that were passed in January by the new administration seem to have a direct impact on that cultural shift. And we're going to talk a little bit about, there's been a lot of executive orders. We're not going to talk about them all, just the ones that impact diversity, equity, inclusion as it relates to you as an employer. So the focus was kind of on breaking down some of these DEI efforts and arguably shifting things again. So let's talk about some of those executive orders next. The first one we'll talk about is Executive Order 14173. They're getting a lot of attention, and people tend to be confused by them and their impact on their own DEI efforts. So we'll attempt here to explain some of this stuff here. This order is ending illegal discrimination and restoring merit-based opportunity. It takes the position that certain DEI programs create a discriminatory preference to certain minority groups that violate the federal civil rights laws. And this order, again, was issued in January, shortly after the new administration took office. And again, it's saying that it's violating certain, for example, Title VII and ADA laws. And then it revokes federal contractor and subcontractor affirmative action requirements, other than veterans and individuals with disabilities. So in the past, federal contractors that have 50 or more employees and at least 50,000 in federal contracts, so it may not be you, have had to write a written affirmative action program, and they had to do self-audits on themselves to ensure that they were creating opportunities for underrepresented groups. So that's changed with this executive order. That's been pulled back. And then the other thing that happened with this executive order is that they require the Attorney General to provide recommendations for combating illegal DEI and identify potential high-profile civil compliance investigations, which is where the news kind of took off with it and has been really kind of in the highlight of things. Because with the Attorney General, they were asked to select 10 large corporations for enforcement who are engaging what they consider illegal DE&I. So this is likely why you've seen corporations start to pull back. They didn't want to be part of this large companies that are going to be exposed or be investigated. So they kind of pulled back from their efforts and their programs and all that so that they wouldn't be targeted. So companies like Target, Walmart, Amazon were some of these that scaled back quite a bit on their programs that they had in place. There is a new guidance by the EEOC. Remember, the EEOC is that Equal Opportunity Commission that is the federal agency. We have our own in California, which we'll discuss soon here and how that relates to California. So this new guidance, you can follow this bit.ly if you'd like to see a little bit more about what this means. So does EO 14173 make DEI illegal? That's a big question we get asked, a lot of confusion on it, and the answer is no. The executive order does not change discrimination laws. We still have Title VII. We still have ADA. Those are federal discrimination laws. So it is a misconception that only also minority groups are protected under the law. All employees are protected from discrimination based on factors like sex, religion, race. Doesn't matter which race, we're all protected. So they're not necessarily only if you're part of a minority group, it's all, whether they're part of a minority or a majority group, we're all related. It's all under that same discrimination law. So your employment decisions that are based on protected characteristics, if you're discriminating based on that, no matter who it is, they've always been illegal and they continue to be. So as a practical matter though, employers with DEI programs may come under increased scrutiny and enforcement, particularly large corporations, and that's why they're scaling back. But that's kind of an explanation of that executive order. So remember, DEI programs, diversity, equity, and inclusion, they're fine. These programs are fine. They're not unlawful to keep them. In fact, some companies are embracing them more than ever. So if you maintain a DEI program, just ensure the following: that it's, again, not unlawful, that you're making good employment decisions, you're not giving preferential treatment to one specific race, sex, or any other protected class, that you're not doing quotas. It used to be people did quotas, and certain government agencies would do quotas based on race, sex, etc. Not doing any of that. We're not using points for applicants for certain protected classes or minority groups when interviewing. Again, sometimes this was mandated by law, and it is still mandated by law. The only one we can think of is when we give preference, what we call points, or you get a higher chance if you're hiring veterans, then that is allowed. Voluntary employee membership groups should be open to all. We can't have, for example, a group at your organization at work that is for women only. We have to have these voluntary employee memberships open to everyone. So a pro tip here is maintain updated job descriptions, because that will tell you a non-discriminatory reason why we need to hire certain people, what the qualifications are, and they're meant to just be, if you meet those qualifications, you're eligible for the position, regardless of your protected class. Okay, so that's a good way to combat this for your hiring and your promotions. So another executive order that's gotten a lot of attention is 14168, which is a mouthful. Defending women from gender ideology, extremism, and restoring biological truth to the federal government. And basically, this states that the federal government will recognize only two sexes, male and female. It defines sex as an immutable biological classification and rejects any kind of gender identity concept. So it rejects the interpretation of this Supreme Court ruling. There was a Supreme Court ruling, I believe it's called the Bostock case, that had a ruling related to sex discrimination, and they're saying we don't want you to use that case, and so that executive order addresses there. So there isn't a Supreme Court case directly addressing gender identity and access to, for example, bathrooms or locker rooms, and so the executive order is saying don't use that Supreme Court case to, like, don't twist it around to make that requirement happen in this case as well. So what does this mean for California? Is this in conflict with California law? Because the Fair Employment Housing Act has a different definition. And the answer is possibly, maybe. They may be in conflict. Which one do you follow? We typically follow the one that's more restrictive to the employee, the one that favors the employee more. So under California's FEHA, the Fair Employment Housing Act, gender identity and expression are protected classes and are required also to be covered under our harassment prevention training. So if you're keeping up, which you should be, with your harassment prevention training, we're still training on that definition of gender identity and expression. The Fair Employment Housing Act in California, those regulations also require employees to have a right to use a restroom or locker room that corresponds to their gender identity and be addressed in the name or pronoun of their gender identity and expression, which means you can still be sued under harassment under FEHA in California. So in California, we want to make sure we follow, again, the more restrictive protection for the employees. We'll have to see what the laws, if they go head to head. We haven't seen it yet because we're 6 months into the year, but we don't want you to have a harassment claim against you with the Civil Rights Department, which you're under California law right now. So we're going to continue to keep an eye on it and kind of take a wait and see approach regarding the EEOC, which is why it's great you're here and you're following some of these guidance that you need, because as we know, laws change all the time. So we're doing it mid-year, we do it again annually, and to cover us between now and January, we will have blog updates. So if you don't already follow us now so that we can keep you up to date. Okay. I think I saw a question in the chat.
You did. I was
okay.
just waiting for a brief break so I could read it out loud for you. So
okay.
I love this question. It's my first time seeing one like this.
Okay.
We have an employee who was hired in 1986 and is still employed, but she doesn't have an I-9. So after doing some research, it looks like employees that were employed on or before November 6th, 1986 do not need an I-9. She was hired on December 22nd in 86. So does she need a Form I-9?
So she was hired after the date, so she would need an I-9. And I could understand why you didn't have one. You don't have one right now. But if they were employed on or before November 6th and she was hired December 22nd, then yeah, she would need a Form I-9. And I would do it anyway. Just she's still with you. It's probably something simple that we can ask for. It's probably best practice if, and it sounds like legally you have to have one, but again, if it's even close to that, it's best practice to do that. You may want to consult with counsel as well if you're unsure.
Thank
Thank
you
you.
so much, Astrid.
Okay, so to wrap up this section, review hiring and internal policies to ensure there's no preferential treatment for certain groups, draft objective job-related criteria for any kind of job openings that you have, and then train your hiring managers and recruiters. You want to make sure you have a good partnership with your recruiter as well, because there's potential for them to not be doing things correctly. So we want to make sure that they're advertising the correct way as well. And then maintain those current job descriptions for just a variety of reasons, not just for discrimination reasons, but workers' comp comes into play, lots of reasons why you want to have a good job description. And then continue monitoring those federal developments and pending litigation. Subscribe to our blog. That's the best way we know how to keep in touch with you, to let you know what's going on. We keep up with that stuff daily. And I got stuck here because I wanted to just talk about wage and hour updates here. Let's talk about those. We'll just dive in here. So we know minimum wage, and we're going to go to California now. We're kind of leaving federal and kind of getting into the state here. So we know we're paying our employees minimum wage of $16.50. Our exempt employees have to be, no matter where they are in the state, $68,640. We're making at least that. And our exempt folks are meeting both the salary duties test and then also the job duties test, that they are actually meeting the qualifications to be exempt. We have some tip sheets here if you need to drop down those exempt employees because you just can't continue to keep these rates up. You might want to consider having those exempt folks go hourly. Okay, so we're good for January for now, but I want to know, since we're in Alameda County, we're in that Bay Area, what have you been impacted? Are you impacted by minimum wage requirements where you are? Maybe you're in a position not in just following the state, but you have employees working elsewhere. Maybe they're working in San Francisco. Maybe they're working from home in a certain city, San Diego, Los Angeles, somewhere where Santa Monica, where there is a higher minimum wage. You may not even know. So let me know in the poll if you're impacted by local minimum wage requirements or not. Looks like a lot of you are. Okay. All right, we'll end that poll here just to continue and stay on time. So it looks like a lot of you are impacted by minimum wage. So let's talk a little bit about that, because we know where the employee is physically working is the amount we need to pay. So there's over 40 local minimum wage laws, and lots of them increasing on July 1st. Rather than put them all out here, we provided a bit.ly here for you, and I'm sure Stephanie will provide it in the chat as well, to follow the July 1st increases. So check and make sure that we're looking at things, not just minimum wage, but also sick leave laws in that area, municipality where there might be a higher minimum wage, that we're looking at predictive schedule, flex time, all that kind of stuff. So keep in touch with that, and know that July 1st comes a lot of increases, and then we'll look again at January 1st, mostly for the state ones as well. But we keep those up to date all the time. So if you always want to check in, and that's a free resource that we provide, you can look at what the minimum wage and sick leave are for those municipalities. We have a couple of industry specific ones that I'll kind of review quickly. It might not impact everyone here, but if you visit your local restaurant and order a hamburger, you might realize why it's gone up. Because April 1st of last year, we established what's called a fast food council, which is very unique in California. And this fast food council just kind of, they elected themselves to be part of this board, and they decided to increase fast food workers to $20 an hour. And they have made it clear now that if you have an exempt manager at these restaurants, that they meet the qualifications for these fast food establishments, if they truly are a manager meeting that exempt classification, they need to earn at least $83,200. So that's an industry where it's unique, where it needs to be a higher salary, which probably makes most managers at these restaurants hourly. It is limited service restaurants, part of a chain that's large, 60 or more nationally. There may be some increases on the horizon, which is why we're mentioning it at mid-year, because there is a union push for the increase to be at $20.70. They are considering it. We haven't seen something, they have to actually have a meeting about this and vote on it, and we haven't seen that quite yet, but there is talk and buzz about this increase coming. So if this is your industry, or if you're just kind of curious about your burger price going up, this may happen in the near future. But healthcare minimum wage, there may be some healthcare people out here as well. And there's an increase on July 1st to that for all covered minimum wage healthcare workers. This went up October 13th. There was that requirement that's increases effective July 1st, 2025. That's just around the corner for most healthcare facilities. I'm going to encourage you to click on this bit.ly that's here if this is you, if this is your organization and your industry, and you can always call into the hotline too, because this is going to impact you come July 1st. But there's very unique circumstances of when an employer is qualified under this healthcare facility, what that means, what the definition is. So there's also some exemptions. Exempt employees have to earn a certain amount of minimum wage or the 2 times the California minimum wage, whichever is greater. So there's a calculation that needs to be done there. So if this is you, follow the bit.ly. There's a wonderful Q&A of whether this is going to apply to you or not, depending on how large of an employer you are in the healthcare system, and if this is going to impact you or not. Okay, so we got a court decision on meal breaks, so we want to talk about this new court case. We don't get a lot of court case decisions these days. We used to for some time, we were getting quite a bit, but this one's on meal breaks, and we wanted to make sure it's worthwhile. As a refresher, you know, if employees are working over 5 hours and up to 10, you are required to give them up to a 30-minute unpaid meal break. A waiver is allowed with mutual consent of employer and employee if the total workday is no more than 6 hours. 6 hours and 1 minute would put you over, and this waiver would not apply. So, and again, if you're working over 10 hours, you are entitled to 2 unpaid meal breaks. Again, you could waive that second meal break if you're working no more than 12 hours and you took that first meal break. Well, with this court case issued an opinion, and we often get questions on meal waivers, and they did hold or affirm that the employee can have a written waiver in advance for the workday if they're only going to work 6 hours. So you probably have been doing this practice, and if you haven't, please do so. Have a waiver that has mutual consent that says that you can revoke the waiver at any time. Make sure that language is in your waiver, because that's what this court case is saying, is they are allowed. We don't have to have one daily. One waiver on file for the employee is sufficient when they're working 6 hours or less, or if that second meal period applies, that can be waived as well. But again, it has to state that it can be revoked at any time without retaliation, and that it's a mutual consent. The employee understands that. One waiver is enough, and we didn't completely have a court case saying that, so we wanted to make sure that since we've probably been doing this, that we are okay and we can continue doing this. So here's a pop quiz. You can kind of just think it to yourself here. We present all new hires that may work shifts of 6 hours or less with a voluntary meal break waiver to sign at the time of onboarding for future work shift. And now you know that this practice is okay with this court case that I kind of went ahead of time, but it does, this appeals court confirmed that this meal waiver break, that practice you probably have been doing, is lawful. So again, we want to make sure it's in writing, it's knowing and voluntary, revocable at any time, no retaliation if they decide to take a lunch break on that day. So best practice is make sure the terms of waiver are written on there, and then train your supervisors, because there is something in the court case that also said supervisors shouldn't be pressuring employees not to take, or coercing them to not take their lunch. So we want to make sure that we're training our supervisors, that we've noted that we've trained our supervisors not to coerce or pressure employees to take their lunch. Something in writing that says we've trained them on that. And that's that Bradbury case you might be hearing about. Okay, a little bit of word on PAGA. We want to make sure we covered this during our January labor law update, but PAGA deserves another mention because it's been good news, and we want good news as employers. So we have very minimal good news on labor law updates. So this is actually a win for employers in California. PAGA is the Private Attorney General Act. PAGA is a California law that allows employees to file lawsuits on behalf of themselves and other employees for labor code violations, mostly wage and hour violations. And they really go for that low-hanging fruit and cost employers, if you've ever been hit with a PAGA lawsuit, with huge fines, civil penalties for these workplace violations. They add up quickly. Many lawsuits that cost employers lots and lots of dollars. Some employers have even shut down because of this. So this reform is great because there's new opportunities for employers to reduce penalties, demonstrating they took reasonable steps to comply with wage and hour law. So another little audit to add to your calendar. We're going to have the I-9. We're going to have the wage and hour audit as well. So this gives you new opportunities to cure. So if you get a PAGA notice, we want you to consult with counsel right away, because there's a way for you to cure that, to take steps right away to try to correct what's happened, what you possibly have done wrong, and maybe not even intentionally. Most of the times it's not intentional. But before you even get to that, before you even get a notice, what this new PAGA reform is saying is you have a chance right now to take reasonable steps should you have something in the future. So they want you to take periodic payroll audits annually. Annually, we're checking our records to make sure that if we've done something wrong, we didn't do penalty pay, for example, on a missed lunch or a missed break, that we're correcting that. And then that we have written policies, that we're going to have our handbook that states employees should go on break, on lunch, when they should go. We have charts that state employees, we inform them, we remind them of this, we train them on it, that we're training our supervisors. We actually have a great wage and hour audit package available for our CEA members. And it comes with a training for your supervisors. It's like a 20-minute training, like a interactive training for your supervisors who may not know all the wage and hour laws. It trains them quickly on that. And then take corrective action for supervisors who are not following your policy. So if you find that a supervisor okayed a timesheet, for example, and they didn't pay a penalty pay for a lunch that was insufficient, maybe they took 28-minute lunch and we didn't pay any kind of extra pay for that, then we are taking corrective action on that supervisor, and we're showing that. So if we're able to take those reasonable steps and in the future get hit with the PAGA claim, those penalties are reduced significantly, quite a bit, decreased quite a bit. Like from, I can't remember I don't know if I have it here, but quite a bit. Penalties are capped also 15%. That's what it is. Penalties are capped at 15% if all reasonable steps were taken prior to being hit with that PAGA notice. So good things here on the wage and hour front. Ensure minimum wage rates are adjusted as needed. Adjust salaries for exempt employees as needed. Have those meal waivers checked and make sure you have that in place, and then do an audit for PAGA reform. It'll really save you thousands and thousands of dollars. And check out our store if that's something, or our membership if you'd like to do follow our PAGA toolkit. Let's move on from paying employees to more of some AI information. We'll kind of quickly go through that since we're kind of on time here. The Civil Rights Department has these AI regulations on March of this year. They approved regulations addressing potential discrimination when AI tools are used to make personnel decisions. So if you have an automated system that's screening applicants, what they're basically saying is there has to be some sort of human touch on that. The date to be July 1st is what they wanted. We don't have quite that yet when it's going to happen, but they're taking some action. They will be taking some action once this passes. So these automatic systems that you have in place, any kind of AI that you're using, it's great, but just make sure that they're not discriminating unintentionally. So FEHA applies to AI. AI tools may result in adverse impact discrimination. So what they're saying is if you're doing some certain things like background checks or criminal history, and criminal history, as you know, in California requires an individualized assessment. It's not enough for you to get the report from software that you're using and use that. There has to be that human element. You have to touch that. You have to do that individualized assessment personally as well. So there's also record retentions of AI-related records. If you're not touching them, but your AI is touching these applications or taking any kind of personnel forms that are being generated, you do need to keep those, okay, for 4 years from the date of creation. So be aware of that. There's a case that came up, the Manos case. It's for unpaid leave as a reasonable accommodation. So in this case, the employee had exhausted any FMLA. They had gone through their 12 weeks of FMLA, but they couldn't come back. And this has probably happened to you as an employer. They're unable to come back, and I want to terminate them. They are no longer covered under FMLA. Well, you need to consider the ADA, or under California, the Fair Employment Housing Act, as an accommodation to request further leave. And so that's what this employee did. They said, we need additional leave. I'm not able to come back yet. I need additional leave. And so the employer said, okay, I'll allow you another extension. And then they requested another one. And the employer said, okay, we'll allow you the next extension. But then after multiple leave requests, they actually ultimately asked for a year. And they continued for a year. I'm sorry, they continued this way of doing accommodating for a year. But then they came a note where it was indefinite. The word indefinite was used, as we don't know when this employee is going to be better, and the doctor's saying it's indefinite. There's no expected end date for this leave. And so they terminated the employee, saying we can't continue on like this with an indefinite diagnosis. So the court decision, the employee sued and said that they did not engage in an interactive process under the ADA or under FEHA. Well, the court decided that they kind of ruled in the employer's favor, which is another win for employers. But I want to just highlight the why they did rule in employers' favor. It may not always go this way. It went in their favor because they engaged in what we call the interactive process. They, first of all, granted repeated requests for unpaid leave. They didn't just terminate after 12 weeks. They continued that. And then they reached out to the employee. There was actually a time where they told the employee if they needed a reasonable accommodation, if there was another position they could consider them for, do you want to engage in something where, and the employee actually marked on the form, no, the only accommodation I'm interested in is a leave of absence. And so because of that, and there was an indefinite leave, the employer was okay to say no. So there's no bright line rule for duration of unpaid leave as an accommodation, but the need is there to engage in that an interactive process to maybe identify any other potential accommodation. So we want to just let you know, consult with counsel, call us. We also try and help through those things. We get you to, again, a place where we might say you need to consult with counsel, but there's some other creative ways that you can consider returning an employee as well. So consider all those. And I know I'm on time, but hopefully you can stay on with me for a little longer. We're almost at the end here. So be on the lookout for some labor law posters and notices. The EEOC has a form we always have to give employees, which is called Know Your Rights. And it is undergoing revision due to those ideology to kind of be in line with the executive orders that we talked about earlier. So that's, be on the lookout for that. We will, if you stay in tune with us in our blog, we will notify you if there's an update to that form. Make sure you keep up with those California minimum wage postings if they relate to you in your area. And then the Civil Rights Department have that crime victims notice that you may be aware of. It's supposed to be here by July 1st, which is just around the corner. And of course, they don't have that form yet. But that is a form that will be required once they do have it, and it may come on July 1st. It's going to have to be distributed to all new hires at that time, and then annually from here on out, and then upon request for anybody who requests a crime victim. So stay again in tune with us, or just be on the lookout, because July 1st is right around the corner, and we will need to distribute that form. It's going to be mandatory for all your employees. So ensure you're having that human review of AI processes for the FEHA compliance of AI for record, and then also that you're retaining anything touched by AI. Implement that AI policy. It's always a good idea. We really recommend that, to train your staff on that as well, and train them on the leave of absence and reasonable accommodation in that interactive process. If you're a CA member, we have a whole toolkit on reasonable accommodation as well. And then watch out for those poster updates that are coming. So the final reminders are all under safety for Cal OSHA. We have an indoor heat illness that passed on July 23rd. Hopefully you did that. It's an indoor heat illness standard that went into effect for workplace areas. All employers are pretty much have to comply with this step. Anytime an indoor location reaches or exceeds 82 degrees while employees are present, aim mostly at these areas of where the temperature gets really high, but really it applies to all workplaces that have an indoor space. Remember, we always had an outdoor heat illness as well, so make sure you have both if you have outdoor employees. But under the heat illness, the indoor one, the essential requirements is that you provide water, cool down areas, that there's an emergency response procedure that you follow. There's certain requirements. Cal OSHA actually has the template already for you to download and for you to complete and fill out. So you have to have that. It's a requirement to have that written plan. It's a requirement to train your employees and supervisors on it. And then there's additional high heat requirements if you're in an environment that gets even hotter than 82, that goes and exceeds 87. So just know that template is available by Cal OSHA. And then we're going to get to the last one, which is Workplace Violence Prevention Plan. So our last poll, have you conducted your annual Workplace Violence Prevention staff training in 2025? And let's see. So I know Stephanie is putting that poll out. So if you'd like to participate, let me know if you've conducted that plan, that poll yet. And just as a reminder, we do need to annually solicit employees' feedback and request them, like, how have we done? And we did it 6 months ago in July, but how have we done? Or do we have any other ideas coming into 2025? You're going to annually review that workplace violence prevention plan, what has worked, what hasn't worked. You're going to provide that training, so we want you to have that on your calendar because that is an annual requirement. If you did it in July, here we are almost in July, and that's going to be due again. That you're doing hazard inspections, you're having safety meetings, you're putting it on your plan. Again, if you are a CEA member, we have a comprehensive do-it-yourself package. We actually also have it for sale. And that's just something we want you to have on your calendar as well. So good, everybody has either done it or it sounds like maybe 60-40. So just a reminder to get it out there, get it done, because you do need to hold them again. All right. So, and the last question is on Cal Savers. Most of you probably already have Cal Savers because you're an employer that's 5 or more. If you were less than 5 employees, your time is up. You have until the end of this year to get your Cal Savers up to date. And I know there was a question about Cal Savers on the Q&A. If our employer retirement plan eligibility is after 1 year, can employee do Cal Savers until eligible? Yes, you can. So just go on to the state. They have a great website on the state's website that provides information on that. And you can actually ask them if you even have that requirement to meet if you already have an existing plan. So you can have a plan that's existing that says you have to be there a year, and that likely will qualify. So, but if you like to participate in that, that's a question for Cal Savers. Go ahead and ask them that and see what what guidance they give you on that. But likely, then I know there's people who bring their Cal Savers from another position, also from another company, to yours, and do you need to keep going? So just be mindful of Cal Savers and what it is. If you do not have a retirement plan, then that will become something that you need to participate in. And again, for the deadline for employers with 1 or more employees is the end of this year. It's a lot of no cost to you, the employer, just an administrative duty to help Cal Savers with this plan. So your summer to-do list, comply with those annual workplace violence prevention plans, staff trainings, develop that heat illness prevention plan. And if you're a tiny little small employer with 1 or 4, make sure you comply with that deadline. So what's next for California employers? Make sure you're staying up to date with those trainings. Those are the ones that kind of get away from us. Keep your employee handbook current because laws change all the time. We want to make sure that your handbook reflect the current laws. And then comply with new wage requirements and pay attention to those local ordinances where your employees might be. And update those labor law posters if needed. Stay tuned, stay close to our blog. I know it's crazy out there. It's mid-year though, and if nobody's told you, you're doing pretty good. You've attended your mid-year labor law update. You now know that you're doing everything probably right, or you have the tools to use to correct that. So as employers, we're facing lots of challenges here, protecting our employees' workforce here, maintaining compliance, safeguarding their mental well-being. So we appreciate you partnering with us at Alameda County. We appreciate Alameda County for hosting this today. We thank you for your attention, and I'm going to throw it back to you, Stephanie.
Thank you so much, Astrid. Like we touched on before, if you need any support above and beyond your no-cost HR hotline provided by Alameda, CEA has a couple of membership tiers for you. They include forms, toolkits, posters, a lot of different options to help keep you compliant and work with you and provide you some peace of mind. All right, and next up we have another shout out for the Alameda hotline. Make sure you write this number down. We are available Monday through Friday, 8 to 5 at 888-202-5668. We have HR subject matter experts just like Astrid here who are on call ready to answer your questions and help guide you through what the law says, what the options might be for your company, and to help give you a nice sounding board and somebody to talk to and help talk you through those options. All right, and we have this survey that we mentioned at the very beginning. I promise it won't take you more than a couple of minutes, maybe 1 minute tops. Snap a photo of the QR code or click the link that I just threw in the chat box. We would love to get your feedback on this presentation. What did you love about it? Where would you like to see some improvements? What topics would you like to hear next time? All great things we would love to see in the survey. All right. The next up is for any HR professionals looking for your continuing education credits. We have your HRCI code here, 708943. And your SHRM code is 25-TVF6D. And those are in the chat box as well if you would like to copy paste. Again, those are for HR professionals looking for their continuing education certification codes. And that is it. We covered a lot of ground today, so we hope to talk to some of you later through that HR hotline. Make sure you have your handouts downloaded and call us back with any questions you might have. Thank you so much, Darlene and Alameda County. We appreciate you having us here today, and we hope to see you all soon.
Thank you.